Hi, everyone. We're very, very early.
Hi, Anabelle. How are you?
Good. How are you doing?
Fine, thank you.
I don't know who
That's
else
right.
who's on, but I know somebody asked me to give them a call today, and I've not been able to get there yet. So,
Okay.
but I will after the meeting. I literally just hung up with a resident now, telling her I had to get going. So,
Yes, it's
I've
early.
been working all day.
It's early. Yes.
But I will for sure call back. Okay. We're a little early, waiting for the attorney to get on. I'm trying to figure out how to make him a host. So forgive me as I'm making some calls now.
Here is Mr. Glazer.
Oh, there he is. Hi, Mr. Glazer, Attorney Glazer. How are you? You're on mute.
Hear me now?
Yes.
Hey, hi. People like to mute attorneys. It's good.
You're all right. Not you though.
How are you?
Not
How are you?
Good, good. So let's try to figure this out. I think I can, if I make you a host, my options are make a host, make a co-host.
Yeah, make me a co-host if you don't mind.
No, of course not. Hold on.
I might have to accept it. I don't know.
Hi, Mr. Glazer. I am Jose Espinel. We met 2 years ago in your office.
Hey, how are you?
Not so good.
Not so good.
With the same
That's why
problem.
everybody's...
With the same problem as always.
Hold on 1 second. Let me see. It looks like I can share. Tell me what you see when I do this. Do you see that?
Yay! Yay!
Hey! All right. So when it's my turn, perfect, beautiful. When it's my turn, I'm going to stop sharing. That was good. When it's my turn, I'm ready to roll.
Yay! Awesome.
Okay. So it looks good.
Perfecto.
Perfecto. Absolutely. Okay. I think we'll get a lot of people. Matter of fact, I see some people sent me questions already. So it
awesome.
should work out very well.
A list of questions.
You have questions?
Oh yeah, of course. The residents wrote in. They have questions for you. So
that's great.
I did get some, like literally 3 minutes ago, questions regarding co-ops.
Yeah, that's what I got also. So you know, what I'm gonna do? I'm gonna cheat a little bit if you don't mind. I'm gonna look right now and see if I can look at the Florida statutes on co-ops, because it's so few and far between. You grow up in New York, you grow up in a co-op. You grow up here, it's all condo and HOA.
Excuse me, I don't have COVID or I'm not sick, it's just allergies.
I know you can't catch it through the computer, so I'm not concerned.
No, I know, but you know.
Let's see. Let's see. You know, co-ops are one of those things where they're oftentimes skipped over by the legislature.
Yes, and that's part of what the complaint was.
So this does apply to co-ops. Okay.
Now let me print out. Yeah, I have HOA questions. Then we got these co-op, and I had some residents that wrote in a few questions as well. But for my fellow HOA friends and neighbors, I want to get some in there as well, because they feel like they've been left out. So
I'm gonna have to open up all the statutes here. My computer.
Take your time. I know we were early to, you know, make
Oh, that's
sure.
all right. I'm gonna have to
Figure
make
this
up
out.
stuff.
Yep.
I'll make up the answers. It doesn't matter.
Yeah, of course.
It's a joke, don't worry. We're good. 7:20. So this was supposed to focus somewhat on crime, right?
Excuse me, repeat that.
This was,
please?
the focus was a little, at least a little bit on crime, right?
Yes, of course.
Now
You
I
know, there, a lot of the complaints are, you know, condo fraud, and
Yeah.
we actually really have some legitimate concerns. But I thought maybe you could cover a little bit on Kaufman language too.
Okay, yeah, so I'll talk about what happened actually starting in 2017, coming out of Miami-Dade County, with all the new changes. That's the grand jury report. I'll start with that. And
Great.
we can certainly go back and talk about Kaufman language, sure.
Awesome. And Representative Julio Robaina is going to be on as well, as you
Yeah.
know.
Of course.
He has such nice things to say about you.
Oh, mutual. Unfortunately, he's not in the legislature anymore, and it's a problem. No one really has taken the bull by the horns.
And you're right about that, but luckily we have Senator Rodriguez there, and you know, she works very closely with him. So
okay, I hope she comes through this year, and
it's not her. You know, let me tell you, it's not her. She actually had some really great bill that she was bringing forward, and she couldn't get any support. And then all of a sudden, after the collapse, you know, you have
I drafted that bill, and I was hoping a lot of the bill, and I was hoping it would go through, and you know, some stuff went through this year, but not much. But I think big difference, obviously, next year. Condo law is going to be right at the forefront because of the tragedy in Surfside. I would think that might be on some people's minds tonight.
Yeah, so this is the third one. We have one more next week, and then we're going to have it probably every three to 4 weeks, unless someone says, "Oh, can you do like a fifth one?"
Yeah,
like 2 weeks from now. Maybe I'll add one more. But this is our third one, and you know, the questions keep coming in.
That's what I do on the radio. I take the questions as they come. So, you know, I enjoy it. It's good. No problem.
Yeah. So, you know, I went to a meeting with like a get together, and there were some both state and federal elected officials, and one of them was talking about how, you know, years ago she wrote language for a bill. I'm not going to say who it is publicly, and you know, she had no idea what Kaufman language was.
Right.
None.
Nobody does.
Yeah. Which is
nobody does, believe me. You know, when I argued that case in front of the Supreme Court, it's so funny. After the decision came out, everybody was like, "Oh, come on, there's no way Eric could have won that case." Everybody knew. It's such nonsense. Before that case was argued, nobody, and I mean even the attorneys, knew about what Kaufman language was and how important it is in your docs. But suddenly everybody was an expert after the fact. You know, it's how it goes.
Yeah, so
it's important. It's important stuff. It really is.
It is, and I, you know, definitely share with the residents how helpful you were.
Thank you.
With language last year for me, and
isn't it weird that you can have two buildings in Hallandale? It looks the same, right next to each other on the same block, you know, and depending upon what the developer put in the documents, one of the buildings are governed by today's law, the other building is governed by the law in 1998. Isn't it bizarre? Mm-hmm. Nobody really knows that's the way it is. Nobody knows it, you know.
Yeah, I mean, what I've done with.
No, the legislators don't know it. I'll tell you that.
Oh, I know that. I know that, and I was, you know, honestly, I was really shocked. Let me turn this on. second. I'm gonna turn the closed caption on.
Okay.
Let's see if it works. Yes, it's working. Okay, perfect. So we haven't officially started the meeting, but since we have some residents, we're early. We're about 20 minutes early, but we'll
Yeah.
start the closed captioning now so that anyone else
That's
that wants to
great.
watch this later
So
can.
I've never seen that work. So it actually flashes the words across the board?
You've never seen that before?
No, not on Zoom. No, I've never used it before. It's
Oh,
incredible.
yeah. So if you look all the way at the bottom, you'll see live transcript.
Yeah,
And
live
then you
transfer,
can,
right. And you can click on it and it does it. Amazing,
yeah, yes,
incredible.
yes. So
Absolutely.
in order for us to publish it on city website, we have to have closed caption.
Right. Amazing.
Yeah, so
I was in, my
helpful.
office was in Hallandale for many, many years. 1920
to come back.
Hallandale, 1920 building, if you're familiar with it. Hallandale
Yes,
Beach
of course.
Boulevard. Yeah. I was there for probably a dozen years.
Whoa,
Yeah.
and we lost you.
Yeah, well, I got lucky. They building condo offices right by my house. So for the last 12 years, I roll out of bed and I'm in work in a minute. So
That is awesome.
very convenient. Yeah.
Yeah, for sure. Not a long commute. All right.
Is Donna joining us?
I'm sorry?
Donna going to be joining us?
I hope so.
Yeah. Okay. Very good.
I hope so. Yeah,
Sitting
I'm
here
sure
a while.
she will. We're just a little bit early. So
Yep.
I'm actually gonna go make myself a cup of tea.
I'm going to do
And
the same. It's a good idea.
yes, and anyone else that's on here, if you want to go get a drink, and we're gonna start at 6:30. We got on a little bit early just to make sure that Attorney Glazer has a presentation for you, and we wanted to make sure you'd be able to watch it, and that he would be able to share it. So we're a little early, but we will be back in about, I don't know, 15 minutes. What time is it? Yeah, about 13 minutes or so. We'll be back 13, 15 minutes. So might want to go make yourself a cup of tea, and we'll see you soon in a few minutes. I'm just going to take myself off camera, but I'm around.
when we would finally get rid of Grace. Now, despite everything that's going on in the tropics with Fred and Grace and Henri, we have no local tropical worries. Everything is staying away from us, which is great. It'll be a mostly sunny and hot week instead. And of course, this is the hottest time of the year with the average high near 95 degrees. So when you combine plenty of sun with the hottest time of the year, that means that all these days are going to be very, very, very hot. A lot of the rainfall is over the west half of the Florida Peninsula. The reason for that is because we have a good east flow, an east to west wind flow, in part because of Grace down there in the Caribbean, right? I mean, the this day when you have a vacation because everything was just a big mess. It was like a construction zone. A large dumpster, work trucks, construction materials surrounded the home. There was no windows in the back. It was just like a house was being built. And when they called Verba,
Good evening, everyone. We're going to start in a few minutes. We're a few minutes early. So we're going to, hi, Donna. So give us a few minutes. If I could ask everyone to please mute yourselves, I'd really appreciate it. Thank you.
Is this the meeting of City Hall? Oh, there's Annabelle.
Hi,
Annabelle,
how are you?
I'm fine. How are you?
I'm well, thank you. I'm going to take myself off of camera. I'll be right back. But this is for the condo and HOA
Good.
town hall, okay? I'll be right
Thank
back. Of
Thank you.
course.
Hi, Rose.
Oh, hi. How are you, darling?
Good. Long time no see.
I know. How are you?
I'm good.
How's
Look
everything?
great as always, gorgeous
Oh.
as always.
Oh my God. I have to scoot this chair up. Why fall out of it? Okay. So what are we doing now?
Waiting for Anabelle.
Okay, she was just here, but she just left. She'll be right back.
Here she is.
Here's
Good evening.
Anabelle.
Hi, Alan. How are you?
Hi, Anabelle.
We're gonna just wait another minute or so and let others log on, and we'll get started.
Great. I'm expecting a lot of people.
Well, let's see. I mean, it's sometimes they fluctuate from 100. Last one we had 77. Last week we had about 48.
Oh, okay.
Yeah.
So is this weekly? Is this weekly, Anabelle?
So I have one more coming up next week. I may add one more week after that, and then I'll probably have these every 3 weeks.
Mhm.
But because there were so many questions, and it was after the tragedy in Surfside, and as a
Yes, of
commission
course.
we were off in July, I thought let's get the residents together and a few elected officials and the ombudsman, which I'll introduce, and to answer questions. I know I'd have concerns. I don't have to say the building you live at, but I think I remember which one.
The popular one.
The popular one, yeah. Well, there seems to be a couple of popular ones, but I remember meeting with you. A beautiful lady, and I was struck by your beauty when I met you a couple of years ago. You're very
Oh my God. Oh no, it's all concealers do. Don't let this fool you.
Whatever it is, it's working.
It takes a lot of work to be me. Thank you.
I'm sure it, as it does always. I think I don't know if the mayor's on. I see Commissioner Lazaro is on.
Oh, okay.
I invited all the elected officials. So last
Oh, that's
week,
nice.
yeah. So Commissioner Lazaro has been on. This is the third week, so she's been on with us. And then last week we had the mayor. I don't know if she'll join tonight or not, but we'll have one next week. We might add one more. So
okay. Michelle has been really, really great, by the way.
Oh, good.
I mean,
Well, she's
well,
on.
everybody else also, but she really.
Well, she's on, so say hi.
Hi, Rose.
Hi, Michelle.
Hi, Michelle.
Hi, Alan. How you doing?
Hi, Michelle.
Hi, Alan.
Where are you? I don't see you.
She's drinking something with leaves.
The top corner. The top corner. Right next to you. I'm right next to you.
Yeah, I just got done working out, so I'm not made up, and I'm not sitting right up close to the camera. Sorry, it's not happening.
She
Don't
worked out.
worry.
My God, so envious.
All right, so it is 6:34. I think we've given everyone enough time to get on. We have a lot to cover. Let me just try to see. I know that we have the Honorable former State Representative Julio Robaina is on, and we have Attorney Eric Glazer on, who is going to give you a great presentation. But I want to give a very special thank you to our Ombudsman, Spencer Hennings, because he literally got on. I sent him a text message 10 minutes ago, and I said, there's a resident that asked a question and has to do with co-ops. And he's like, are you having a meeting tonight? And he's like, he changed his time and schedule, so he's on as well. And I am very, very thankful. So thank you, Spencer Hennings. And then we have the Broward, Palm Beach, and St. Lucie Realtor Association. They're on here as well. as well as the Miami Realtor Association. So thank you to both associations. There's some new faces here, so I just want to let you know that both Realtor associations were very generous. We both made donations to the city. We have an online portal, and I'll go over that with you at the end of the meeting. But
Not from the side. No.
hi, everyone. We see you and we hear you. If you could all please mute yourselves, it would be wonderful. And let me just mute everyone. And then Attorney Glazer and Mr. Robaina and our lovely ombudsman, if you would, I've made you co-host. So, hi, everyone, please mute yourselves. Otherwise, I'm gonna have to put you in another, I'll have to log you off. So please make sure you're muted. All right, so good evening, everyone. This is our third meeting. We have one next week. I might add on one more the following week. For those of you who don't know who I am, there's new faces. My name is Anabelle Lima-Taub. I'm one of the commissioners in Hallandale Beach. I am the sponsor of the Condominium and HOA Transparency Act. It's an ordinance, but I want to give a special thanks to residents. You know who you are, that were very helpful in making sure that this ordinance would pass. But the two gentlemen that are really responsible for any policies that I've worked on related to condo fraud, HOA fraud, are on tonight's Zoom meeting. And that is former State Representative Julio Robaina, who'll introduce himself. And we also have Attorney Eric Glazer, who was incredibly helpful with language that I reached out with last year, so for the ordinance, but particularly for an issue and a policy known as Kaufman language, and he will go over some of that with you as well. I also want to recognize, I see there's more people logging in, that Ombudsman Spencer Hennings was here 2 weeks ago, if you all recall, and was not scheduled to be on tonight. And I received some questions regarding co-ops, and I literally texted him about 10-12 minutes ago asking the question, and he said, are you on tonight? And he changed his plans, and he's on as well tonight. So thank you very much, and that, you know, shows your dedication. So without further ado, and we also have Commissioner Lazaro's on with the city, Hallandale Beach. I have invited all elected officials. The mayor was here last week. Hopefully she will be able to join next week. So thank you, Commissioner Lazaro. There's a lot to cover. So Commissioner, if any comments that you and I have, let's wait till the end of the meeting so we can allow the speakers to get started. So Attorney Glazer, would you like to introduce yourself? I think you have to unmute yourself.
All right. Good evening, everybody. How are you? Attorney Eric Glazer. I'm practicing condominium and HOA law for just about 30 years now. I'm board certified by the Florida Bar in this area in condominium and plan development law. I see that I represent some of you. I know a lot of you. And I do a radio show every Sunday for the past 13 years called Condo Craze and HOAs. That I know a lot of you listen to on Sundays, and I appreciate it. I've certified many of you by taking my seminar, and that's much appreciated. We've taught about 21,000 people all across the state of Florida. It's something I truly love and enjoy. And of course, I practice with the law firm of Glazer and Sachs, and I look forward to answering your questions tonight. Thank you. Thank you for having me, Commissioner.
Thank you for being on. And we also have former State Representative Julio Robaina on. Would you like to say a few words before we get started? And then I'd like to introduce you to our state ombudsman. For those of you that live in co-ops and feel like we leave you out, he joined on especially because he wanted to address some of the questions. Julio?
Thank you, Commissioner. Can you hear me okay?
Yes.
Yes.
Okay, good. I'm in the middle. I'm sitting in an automobile, so forgive me for my conditions this evening. But anyway, thank you so much for what you're doing. You know, for me, it's an honor and a pleasure to be on these Zoom meetings, and I commend you because most people understand that the world of association law is done at the state level, but you've taken the initiative to start something at the local level. I wish everybody had that type of initiative because this is a big problem that we saw and it needs to be tackled at the state level. There are things that the county government can do, that municipalities can do, and even the federal government is chiming in right now, possibly with some financial support for what is coming. So I'm here to answer questions. You know, I'm here all the time for you. And I'm glad that the realtors are here. They have a very, very good agenda, I believe, this year on things that they're recommending. And I want to later on talk a little bit about that and some of the other things. But finally, I want to keep pushing the condo fraud task force legislation that I've been working on. And that will be filed. We'll actually have a bill by Friday, God willing, that our Senator Ana Maria Rodriguez will be filing in Tallahassee. On that note, I'll be quiet and let everyone else speak. Thank you again for allowing me to be part of this.
Thank you. Ombudsman, Mr. Hennings?
Good evening, everyone. Commissioner Taub, thanks for inviting me on. I think these programs are really phenomenal, so I always do my best to jump on, even if it's last minute. But I just want to say, if anyone has any really complicated legal issues, definitely send them to Eric Glazer. He loves those questions. So he's a phenomenal attorney. I've been on his radio show before. So I'm finishing up some work, then I'm driving home tonight. Gonna try to make it to have dinner with the family. But if I can answer any questions in the meantime, happy to be available.
Thank you. So we did get some questions regarding co-ops, and I will touch on that in a little bit, but I know that Mr. Glazer had a presentation. Would you like to start with it? And
Sure, we absolutely can. Let's see if we can get it going correctly. Okay, here we go. Everybody see that on their screen? The slide? It's working?
Yes.
Okay, great. All right, so a little bit of background. I don't want you to think that the legislature, never focuses on crime and that, whatever happens in condos, the legislature doesn't care about, because I will tell you, in 2017, there was a big change in that regard. So what happened? It's important that you know some of the background. In Miami-Dade County, the state attorney's office was getting all kinds of telephone calls and letters and complaints about condominium associations in Dade County. People were complaining that the people on their board steal from the board, steal from the operating account, steal from the trust account. They were complaining that people only get on the board because they want to divert business to business that they own, right? They want to give all the condo contracts to their friends or family members. And once somebody gets on the board, they basically stay there forever. And that the state agency, the Department of Business and Professional Regulation, that was supposed to help and investigate all of these incidents, all of the complaints, is absolutely not helping them. They're hindering them. So Kathy Fernandez-Rungel, who's the state attorney in Dade County, because she got so many of these complaints, she said, okay, here's what we're going to do. We're going to assemble a fact-finding grand jury. Okay, we're going to seat a bunch of grand jurors, and the grand jurors will hear testimony about just what's going on in Miami-Dade County, and they'll make recommendations. Well, some of you may have heard the saying that, prosecutor can indict a ham sandwich. Why? Because the people that are being accused don't get to testify at the grand jury level. So the grand jury was sitting there for a few weeks, and all they were hearing was people taking the witness stand and hearing negative things and negative things and negative things about board members who serve on their boards in Miami-Dade County. So it was all about, lying, cheating, and stealing that my board members do. And absolutely no testimony came in regarding board members that are good, board members that have served on a board without taking a dollar for the last 2-3 decades. but all they heard was negative stories. So keep that in mind. And then you would think that the Department of Business and Professional Regulation would voluntarily come down and tell the grand jurors just what they do in Tallahassee with all the money that they get. Remember, every one of you that lives in a condominium pays $4 per year to the Department of Business and Professional Regulation. Now, Julio, I don't know if your mic is on, but if it is, why don't you tell everybody what happens with that $4 that everybody pays and how much money it actually turns out to?
Well, good point, Eric. And so you'll know that it accumulates every year in that condo trust fund to over the tune of $13 million. And I've yet to see it used for those that pay into that trust fund, meaning people that live in condominiums. It's swept up into the general revenue and used for other projects in Florida. That's the sad part of it. But you're going to see after you're done, Eric, that we're proposing a piece of legislation that's finally going to go to that trust fund and use that money for what it was intended, to help those who pay into that trust fund. But unfortunately, as you said, they get swept up every year and they get nothing out of that money that they all pay.
It's amazing. And thank God you're drafting such legislation. I think that's fantastic. So again, I was saying that you would think that the Department of Business and Professional Regulation would come down and voluntarily testify in front of this grand jury and tell everybody just what goes on in Tallahassee. No, they refused to come down and testify. Believe it or not, subpoenas were required to have people from the DBPR come down and testify. And when the people did come down, they didn't send the people at the top of the food chain. They sent more or less the lower level lackeys. And what did we find out that does go on at the in Tallahassee? So they hire people to investigate criminal complaints. And you would think some of these people would have a criminal background. They were former police officers, detectives, investigators, even worked for insurance companies. Nope, you absolutely don't need any experience whatsoever. Okay, what kind of training did you get at the Department of Business and Professional Regulation? None. There must be some books, some guidelines, some methods to follow. Are there? None, absolutely not. Okay, so this testimony was being heard by the grand jury for weeks on end. And I urge you, anyone who's tuning in tonight, if you want really good reading, Google the Miami-Dade grand jury report on condominiums. And I promise you, it's something that you will enjoy, maybe not enjoy reading, but you'll certainly find it interesting. So these grand jurors come out with an absolutely scathing report as to the current situation with condos in Miami-Dade. And what does the report basically say? Again, they are rampant with fraud, rampant with stealing. People get on and never leave, and it's just a haven for crime. So this grand jury report now comes out and it goes to all the Florida legislators. So you're a Florida legislature, you're hit with this unbelievably scathing report as to condominiums. What do? So what do? They enact new laws. And now you know why they enacted these new laws, and we'll go over them right now. Now, interestingly, almost none of the laws apply to HOAs, very few. And even for co-ops, it's the same thing. So I guess only bad things happen in condominiums and not in HOAs or co-ops, right? At least according to the Florida legislature. So what did they do? They actually put the word, for the first time, kickback into the actual statute. Everybody knows what a kickback is, right? A kickback is, landscaping company, the president goes over and says, we'll give you the $50,000 a year contract if you kick me back $5,000, right? We all know that's a kickback. So the law for the first time addressed a kickback. An officer, director, or manager cannot accept a kickback for awarding a contract to a vendor. And in an HOA, the one thing they did do, if the board finds that actually happens, the board can immediately remove the officer or director from office. Then the legislature even created more laws. Quite frankly, these things were all illegal to begin with, but they really codified it and they concentrated on what is illegal. So they added forgery of a ballot envelope or a voting certificate used in a condo association election is a felony. The theft or embezzlement of funds of a condo association, felony. The destruction of or the refusal to allow inspection of records in a condo association, that's generally accessible to the owners in furtherance of any crime is punishable as a felony. So in other words, if a director doesn't allow access to records because they're covering up evidence of another crime, that is a felony in and of itself. Again, if you look at this, it applies to condominium associations. It does not apply to HOAs or co-ops. So if you live in those communities, just keep on forging, keep on stealing, I guess. Again, it doesn't apply in those communities. What about new ways of removing directors? An officer or director charged by information or indictment now in a condo with forgery of election materials, destruction of records, refusal to allow access to records in order to cover up crime, and in both a condo and HOA, embezzlement, you are removed from office upon your arrest or your indictment. So immediately, if you're arrested or indicted for any of those things, you're removed. And that's exactly how it's done with elected officials throughout the state. You're removed pending a determination of the charges against you. And if it's found that you didn't do anything wrong, you're put back in office. But while those charges are being determined, you are removed pending a final outcome. Then they focused on debit cards. Okay, I can tell you why did this happen? Because presidents more than once were caught at the Hard Rock Hotel and Casino using the debit card of the condo association to play blackjack, right? So how does it work now? Again, condo only. An association and its officers, directors, employees, and agents, you cannot use a debit card issued in the name of the association. Can you still use a credit card? Yes, okay, but there's a difference is a debit card, as you know, the money comes out right away from the account, can't use it in a condo association. And here's, again, I told you in the beginning, here's something that went back and forth for a few years in a row. And it has to do with, again, this grand jurors were told that people get on the board of directors because they want to divert the condos contracts to businesses they own, or that their friends own, or that their family owns. So for immediately after that grand jury report came out, the law changed and says, absolutely not, you can't do it, no way. Then the law has been modified since 2017. And let's assume that the president of a condo in Hallandale and the board agree that it's time to paint the building, right? It's time to paint the condo building. And the president is a general contractor. And the president says to the board, hey guys, I've been a general contractor for 25 years. My business is located here in Hallandale. I'm licensed, I'm insured. I'm certainly going to give you the best price. I'm going to be here supervising the job every single day. I'm your man or woman for this contract, for the paint. Can the board enter into such a contract? And the answer now is yes, they can. The relationship has to be disclosed and put in the minutes at the time the board votes to approve the contract. It actually has to go in the contract as well. And the contract has to be voted upon by the directors who are not interested, and 2/3 of those directors have to agree to proceed with the contract. Okay? So the president obviously can't vote to send condo business to him or herself. And at the next meeting of the members, the contract has to be disclosed, and the members have a right to cancel it upon a majority vote of the members present. Okay, so again, some people frown on this practice. Some people think it's a good idea. I've seen it work both ways. Sometimes the person has, has every good intention to make sure that this job is going to work out right for the association, and that's the job that goes wrong. So it depends how people feel. There's mixed emotions when it comes to this statute. They were interested, the legislature, in focusing on foreclosures and the fact that sometimes in a condominium, the manager or the management company are the only people that know units are getting foreclosed upon, and they're the ones that show up at the foreclosure sale, and they're the ones that purchase the units at the foreclosure sale. So the legislature had to think about a law that says, can a director or a manager purchase a unit that the condo is foreclosing on? And the new law they came out with, a board member, manager, or management company cannot purchase a unit at a foreclosure sale resulting from the association's foreclosure of its lien for unpaid assessments. Now, what do I think about this statute? I think it's terrible. But I think if a manager or a management company or board member buys a unit at a foreclosure sale from the association's foreclosure, that's fantastic. They owe every single dollar that's owed on that unit when that unit becomes theirs at the foreclosure sale. So here's actually a statute that went too far. What about the attorneys that represent the associations? Can the association's attorney also represent the management company? And notice this is only in a condominium, only in a condo, not in an HOA down at a co-op. An association cannot hire an attorney who represents the management company of the association. So if you're looking around for an attorney, you have to, when interviewing that attorney, say, hey, what's your connection to our management company? If you represent them, then sorry, you have to choose a different attorney. All right, now here's a statute that has gone back and forth many times over the last few years, and it was just amended as of July 1st. So here you had a statute that says, okay, once somebody runs for 8 consecutive, or is on the board for 8 consecutive years, they can still run for the board, but the only way they get on is if they obtain 2/3 of all the votes cast in the election, or there's no competition, right? They win by default. So that was the law. And now the question became is, well, when do you start counting the 8 years back? Do you start counting it right now? Or do you start counting it the year that the law went into effect? And the legislature codified it this year, clarified it, and said, okay, we're going to start counting year 1 in the year 2018. Okay. I think that was absolutely the wrong decision. It was the wrong way to go. That's not what the legislature intended. They didn't intend for a law to take place in 8 years, but that's what they did this year. So you don't start worrying about this new law now until 2026. That's when we'll talk about it. And by the way, in terms of how many people can serve on your board, or not how many people, how many years you can serve on your board, in a condo, again, unlike in an HOA, you can have 2-year terms. You can have 2-year staggered terms, but nothing more than 2 years. And if your bylaws are silent, again, it's going to be running for re-election every year. So keep that in mind. Some ways now directors can be removed from the board. Okay, director more than 90 days delinquent in the payment of any monetary obligation, you're deemed to have abandoned the office. So what does that mean? It means literally if a director is carrying a $50 balance for 90 days, doesn't pay it, that director is automatically off the board. We know, spoke about previously, if you're charged with a felony theft of embezzlement, stealing from the association, you're automatically removed. Now, believe it or not, this was not the law for a long time for HOAs, okay? It was only the law for condominiums. So I was getting calls primarily that came out of Central Florida from HOAs that said, can you help us? What's the problem? In 2 different situations, our president was arrested for stealing association funds, yet in an HOA, yet continues to serve as president from their prison cell. True story. So it wasn't too hard to ask the legislature to make this law apply to HOAs as well, and now it does. The other way you could remove a director, the recall process, which has gone through a whole bunch of changes. What is the recall process? It's a way to remove directors now without waiting for the next election. Generally how it's supposed to work, let's say you live in a 100-unit condominium, 51 of the units sign a ballot voting to remove the director or all of the directors that are currently in office. It gets served on the board, much like you would serve a lawsuit, and the board has to decide whether or not it was done correctly and decide whether or not they're going to certify the recall. If they don't certify the recall, the unit owner representative now has the right to file a petition for arbitration, and an arbitrator decides if the unit owners were correct in trying to remove the board. And again, one of the things that the grand jury was focusing on is that directors typically have tremendous conflicts of interest on various different things and don't disclose that conflict of interest. So now for the first time, the condo statute was amended to require directors to to disclose conflicts of interest. This is Florida Statute 718.3027. Directors and officers of a board that isn't a timeshare and the relatives of the directors and officers must disclose to the board any activity that may reasonably be construed to be a conflict of interest. If you're sitting on a board and you believe you may have a conflict of interest, you probably do. And if you fail to disclose that conflict of interest, the board members themselves have the authority to remove that person from the board. So again, another law in response to what the legislature was hearing from that grand jury report. Board members always have conflicts of interest. Directors never, ever had the ability to remove other directors. Now they do, okay? If they find that another director failed to disclose a conflict of interest, okay? Now, that was my last slide, Commissioner. I know you wanted me to address the situation with Kaufman language. A lot of people don't know what it is, right?
Yes, I just, if you allow me, I believe the Hallandale Beach Mayor Cooper is on. Mayor,
Sure.
Mayor, would you like to unmute yourself and say hi?
Hi all. I'm
How are
sorry.
you?
Hi, good evening. How are you? Thank you so much for your time. Sorry I'm late to the party, but I'm listening in intently. Thank you, Mr. Glazer, for
Thank
your.
you, Mayor. Thank you, Mayor.
Appreciate it.
Thank you.
Thanks.
And Mayor, Ombudsman, Mr. Hennings, joined on last moment as well because we had
Oh,
some residents that had some
Great.
concerns, and he was nice enough to say, let me hop on for a little bit, so he's on as well. Yes, if you could please cover Kaufman language for a little bit, and then
Oh, okay.
I'm going to get right to the questions.
Sure.
I
Okay.
know that there are residents that live in HOA, and I know there's residents that live in co-ops, and you feel like you're kind of like the stepchildren in all of this. So we have questions for you. Just hang on for a little bit. Kaufman language is really, really imperative that each and every one of you knows what Kaufman language is. It's mind-boggling to me how many legislators don't know what Kaufman language is. So,
And people that serve on boards. Yeah.
Mhm.
Okay. So it may surprise all of you to learn that you can have 5 condominiums, let's say in Hallandale, all next to each other. And depending upon when they were built and what language they have in their governing documents, each condominium building may be governed by a different set of laws, believe it or not, okay? So this is a rather complicated topic, but how we'll teach it is we're going to talk very quickly about a case that I argued in front of the Florida Supreme Court, and it's called Cone versus the Grand Condominium Association. So what was the Cone case about? The Cone case was about a very, very large condominium located in the city of Miami. This condominium has 1,200 units. And out of the 1,200 units, 800 of those units were residential units, and 400 of the units were commercial units. There's actually like a mall in this building and hotel type units. But even though the residents outnumbered the commercial unit owners, 800 to 400 or 2 to 1, the bylaws of this particular building, and keep in mind, this building was built in 1986. Keep that in mind, 1986 was when this building was built. The bylaws of this building said it's the commercial unit owners who get to elect a majority of the board. Sounds outrageous, right? The residents live there. They outnumber the commercial unit owners 800 to 400, yet these documents say the commercial unit owners get to elect a majority of the board, 4 of 7. So 21 years later, in 2007, the Florida legislature says, we don't like what's going on in these mixed use condominiums where there's both residents and commercial units. And the Florida legislature passes a law that says, we don't care what your governing documents say going forward. Starting now, and they tried to make the law retroactive, starting now, any condominium, any mixed use condominium where the residents outnumber the commercial unit owners, the residential unit owners get to elect a majority of the board. Okay, so they changed the law completely. Your governing documents now don't mean anything. Well, the commercial unit owners, what do? They file a lawsuit that starts off in the Dade County Circuit Court. It goes up to the 3rd DCA, and then it goes up to the Florida Supreme Court. And you can actually watch this oral argument. Maybe one condo or HOA case makes it to the Florida Supreme Court once every 15 years or so. And it's really interesting to watch the argument in front of 7 justices. So if you want to see it, it's on our firm's website. And they argued, the commercial unit owners say, wait a minute, this new law is unconstitutional. It violates the contracts clause to the United States Constitution. We have a contract. Our declaration is a contract. Our bylaws is a contract. And it guaranteed that as the commercial unit owners, we had a right to elect the majority of the board. It would be unconstitutional to now make that valid contract, that perfectly legal contract, illegal. So the Florida Supreme Court says, okay, we're going to decide this issue as to whether or not it violates the contracts clause on one very, very narrow determination. What does the governing documents, what does the Declaration of the Grand, as recorded in 1986, what does it say? Does it adopt the Florida condominium laws as they exist in 1986 only? Or do the documents say we adopt the Florida condominium laws as they exist in 1986 and as amended from time to time? That's the key language. That's what's called Kaufman language, the as amended from time to time language. Well, unfortunately for the residential unit owners who lived at the Grand's governing documents said that it only adopts the laws as they exist in 1986. And again, this new law that wanted to help the unit owners came out 21 years later in 2007. So the Florida Supreme Court says in this condominium at the Grand, because that language doesn't exist, it's unconstitutional to apply it there. But to further teach you the topic, let's assume that a sister building was built right next to the Grand on the same day, and the documents were recorded on the same day, but the other building has the as amended from time to time language. The 2007 statute would apply in that building, but not at the Grand, even though there are buildings that are standing right next to each other. So again, like I said, we have a situation in Florida now where you can have several condominium associations all on the same block, all governed by a different set of laws. So is it important to make sure the Kaufman language is in your governing documents? Absolutely, because a lot of the powers, for example, that are given to boards would not apply in associations without that language. For example, after the 2007 foreclosure crisis, 2008 foreclosure crisis, boards were given several types of powers. For example, if unit owners are delinquent, we can suspend them from the board. We can prevent them from running for the board. We can prevent them from using the common areas, all of that stuff. Well, guess what? If your condominium was built before 2007 and you don't have the as amended from time to time language in your governing documents, the board has none of those powers, none, including the ability to fine. So a lot of boards are going through the fining process. Their documents were created before the associations were allowed to impose fines, and that was created like 2011 and 12. They don't have the as amended from time to time language. Any fine that you impose is illegal, and the unit owner will beat you in court if challenged. Okay, so what did we find? We find about close to 50% of the associations we were representing did not have this Kaufman language. So what do you do now? Go back. Seriously, take a look. The homework assignment you do have, I like to say, is to go back, take a look at what your governing documents say. If it does not have the Kaufman language, the as amended from time to time language, what you can do is have your unit owners amend the governing documents, right? Like typically it takes like a 3/4 vote or a 66 and a 2/3 vote to amend your governing documents. And you would adopt the Condominium Act or the HOA Act, this applies to HOAs as well, as it exists today and as amended from time to time, okay? And I hope that clarified it. Anybody want to repeat back what I just, no, I'm kidding, okay? But yeah, it's a complicated topic, and I hope I made it, I presented it in a manner that you can understand. Okay, thanks, Commissioner.
Very good.
Thank you. So last year, you were very kind to help me draft a resolution and sponsor resolution and support, excuse me, of Kaufman language and adding Kaufman language also to new developments that come into our city, and as they're being built and they're ready to go, and their condo declaration and docs, usually make a motion for Kaufman language to be a part of their docs. But in speaking with the state legislators, a change has to happen up in Tallahassee. And so maybe either the Ombudsman or Representative Robaina want to chime in, because I speak in layman terms. I'm not an attorney, and so the way I explain it is, when there's new laws that come out to protect condo owners, if Kaufman language is not in their condo docs, and you live in a building that was built, let's say in 1979 or 1986, your building, your association doesn't have to abide by the new laws. So how do we tackle that on a state level? What would be the process? Is my question.
Can't be done. It can't be done because it's a constitutional issue. So the legislature can't come out and make a law that said that the Supreme Court said was unconstitutional suddenly legal. So the only way really to address this is exactly the way you're doing it, which is you really got to get the message out to the condominiums in your jurisdiction and the HOAs in your jurisdiction that you need to amend your governing documents if you want the protection of the new laws that come out.
And I want to say that, remember, none of these laws can be retroactive. That's the thing that people keep asking. Are laws retroactive? They are not retroactive, folks. So that's the problem. So what you're doing is the correct way to go about it. Hope that the boards will initiate the amending of the docs. But I know there is already talk about some new legislation to try to make it mandatory that, again, you can't go against the Supreme Court's, ruling. But the bottom line is that for all new development in Florida, they would have that in their docs.
That's great. That's great if that was actually passed by the legislature.
I mean, that's definitely something I advocate for, and thankfully have the support of my colleagues that are on here today for Hallandale Beach. But I also think that it's really important for all of you. I think we have 94 people on today. So I think it's really important for the residents, for condo owners, HOA owners. Correct me if I'm wrong. If co-ops could add the language as well. I'm not sure.
Yeah. In their bylaws, yes, they probably can.
So, for you to maybe have new elections and have, if you're going to serve on a board, or your neighbor is going to serve on a board, to implore them to add Kaufman language. It's not too late to add. It's an amendment. I think does it have to pass with 75% support of the condo owners, or?
It depends what that declaration says. Some declarations allow amendments with 2/3, some require 3/4. So you got to see what actually your declaration says.
So I will absolutely, I believe I have a source for residents who want to work on adding Kaufman language to your rules and regulations and your condo docs. So perhaps we can follow up on Kaufman language next week or maybe the following week. But I think it bears, another meeting for us to discuss this further and help out our residents. I think I have a source for you, and I will work on it. And if it's confirmed, I will send out an email.
Annabelle, I have a question. Is there a format or any type of petition language that we can share with condominium owners that they could circulate and get signed onto it? Is it the same petition process? Or would this be governed simply by the board of directors to ask the question in an election? Does that depend on the documents as well? That's to anybody, I guess.
Again, it all boils down to the board taking the initiative to amend it. That's really what it boils down to. Is the board going to go forward and do what they need to do?
Okay.
And a lot of boards, just absolutely don't realize that as the new laws come out, it doesn't apply to them. They automatically assume the new laws apply, and oftentimes they don't.
Well, and no disrespect to all the attorneys in the room, but wouldn't that be on the shoulders of their attorney to explain and to encourage them to protect
Objection? I'm
themselves
kidding.
and, yeah. Yeah.
No, absolutely. No two ways about it. When the attorney should absolutely be advising their association clientele that if, let's say the association says, go after this person, file a foreclosure or send them a letter because they violated something. The first thing that attorney has to know in a lot of circumstances is, wait a minute, do you have the as amended from time to time language? I can tell you in our firm, we have told countless associations who have asked us to do something. Sorry, we can't do that. What do you mean you can't do that? We can't do that because you never bothered to put the as amended from time to time language in your governing documents. So you don't have the power to do that. Happens all the time. All the time.
Well, thank you for that.
Thank you, Mayor.
I have a
Madam
question
Mayor,
for you.
another,
I'm sorry, go
Hi.
ahead.
I was gonna say, yeah, another person responsible, of course, the attorneys have to give legal opinions, but remember, there's this thing called a licensed manager, a CAM. A CAM should also be talking to their board and letting them know, because if you're a good CAM, the day you get hired, you will have already read the docs for that association and highlight things that should have been brought to their attention. The CAM can do it. The CAM just cannot give legal opinion. The attorney will do that, but it's important that CAMs, if they know what they're doing, they will read and also recommend this to their board of directors.
You're 100% right, Julio, because I can tell you, CAMs can get in trouble too. If the boards tell them to do something and as amended from time to time language is in there and they do it, well, they can face a lawsuit as well. So you got to be really careful.
Good.
I agree with that. 100%.
I'm crafting a letter for my meeting next Monday in regards to certain parties' ownership of each issue. So I think that needs to be delineated. And a lot of individuals depend on their livelihoods for this. And I'm not speaking to, again, not directly to anyone on this call, but in general, that it's quite difficult. And I think there's a time to be held accountable in each one's profession to ensure that they're operating and not simply worried about their jobs, which in an ideal world would happen with the ethics of individuals, but it's not.
Could not agree with you more.
Thank you.
By the way, one other thing, Madam Mayor and Eric and Commissioner, if I may, one of the things, seeing that Eric is, I would say, one of the attorneys who's probably the most proactive, probably has certified more board members than any law firm that I know. I think he would agree that one of the things we do have to remove in law is this affidavit that's signed by people that claim they read 718. That was put in a bill that I wrote as, again, as another one of these, lumps that you take when the lobbying corps says, well, that was too harsh. Well, if you were to probably ask the majority of the people that signed an affidavit, they never read 718. They don't know anything. I think that there should be a mandatory course. And I would go as far as saying at least a whole day where they can learn what their real responsibilities are, so that the cart is not, the cart's not, leading the horse. Because unfortunately, when they don't know what they're doing and they sign some affidavit, who still has the upper hand? They're being led by either a property manager or at times an attorney. These board members are volunteers. They don't know what they're doing. So we need to abolish that affidavit altogether and make it a mandatory type course. That said, go ahead, Eric.
Julio, you know how I feel about that. I said earlier, I certified about 21,000 directors throughout the state at this point who bothered to take the course. I just want to let everyone know, in Florida, you have to get certified within 90 days of getting on the board. If not, technically you're off the board. And there's two ways to get certified. One is by signing that ridiculous form that Mr. Robaina is talking about. And the form basically says, I read my governing documents and I promise to enforce them, right? And a lot of documents have illegal provisions in them. So believe it or not, the state of Florida is certifying you if you promise to enforce the illegal provisions in your governing documents. Now you're good enough to serve on the board of directors, okay? The other way of getting certified, and you literally pointed out, and Julio, let me say this. You know how many times I've been at an annual meeting where the people win, they get on the board of directors. Immediately at that meeting, the manager hands out the form that says, sign this, and it says, I've read the governing documents. They got on the
Yes,
board
sir.
30 seconds ago. They didn't read any governing documents, right? Yet the manager
That's-
passes out the form to sign. So the other way of getting certified, of course, is by taking a class. And so proud of the fact that you taught so many people, they enjoy it. The reviews are always great. They learn something for a few hours. And if they can't take a class for 2 or 3 hours, Julio wants to do it even longer than that, then they should never get a vote to be on the board, and they should never be allowed to be on the board. They should never be certified. Signing that affidavit is an insult to everybody who actually wakes up and goes to the seminar. And by the way, how are we doing it now? Online, many times. So there's absolutely no excuse to allow certification by signing that ridiculous self-serving form.
May I ask a question?
Sure.
Commissioner Taub? How can we help you help that circumstance? What can we empower you to do to say that that's illegal?
Yeah.
Because obviously, I'm sure you said you cannot do that. You need to take a course. But obviously, there's a lot of people that wouldn't do that and take that measure to call out their board.
Oh, I think if,
What would you
Julio,
suggest
correct me
we
if I'm
do?
wrong. Yeah,
Yep.
Julio, correct me if I'm wrong. I think if various commissions actually sent a letter or proposal to the members of the legislature, that would get this passed, absolutely. Yeah, I can tell you this, it was actually in a bill I helped draft 2 years ago, and at the last second, all the condo bills died. So I'm hoping this year that it's actually going to go through. But if municipalities want it, I think it goes through without question. Listen,
Madam Mayor, if
I'll
I
say
may,
this. Let me just say one thing about the tragedy in Surfside. Understand, a lot of people don't even know how the reserve system is supposed to work. They don't even know, and I'm not saying that that's what happened here, but they don't even know how the reserve system is supposed to work. They don't know how to fund it. They don't know if they have to fund it. They don't know if it needs to be waived each year. You know how many times I sat down with the board and I said, tell me about how much money you're putting away. Tell me about your reserve account. And they'll tell me, no, we voted to waive reserves. When did you vote to waive reserves? 2003.
Right.
Wait a minute, you have to do it every year. Oh, we only thought we had to do it once. So how are you going to learn that? How are you going to learn your responsibility to fund a reserve account and protect the property from falling down, right? If you're signing an affidavit and not attending the class, okay? So
Let's-
that's my pet project.
And by the way, last thing, I've got to get this in here. Madam Mayor, that's the reason why the state needs to have a fraud task force. I sat in Tallahassee for 8 years. I took the lead on writing these laws. Your city, Madam Mayor, Commissioner, were the ones that had one of the first arrests ever. And I'm always very proud to say that Hallandale Beach was the pioneers in doing what needed to be done. But it took the effort of assigning a detective to do that. But, you know, I'm not the biggest fan of DBPR. I can say this because I work with them. To me, they are nothing more than a bureaucratic agency that pushes paper, but nothing gets done. I think that it's long overdue because we can continue to write laws, but the more laws we write without the enforcement part of it, they're no good. You've got to have enforcement. You got to have the fraud, part of it. And I know, Commissioner, we'll do another Zoom meeting someday once the bill is out, hopefully by the end of the week, so that everyone can understand what this condo fraud is. And it's a private public. It's where you're going to have law enforcement people that know what they're doing so that your state attorneys are not doing investigations and there's no need for these grand jury, type of reports, that it's done by certified law enforcement officers that know what they're doing. That said, let's give the folks a chance because we'll have plenty of time to talk about this. And I know there's a lot of questions you have.
Thanks.
So
Yeah, so thank you. Let me get right to it. We will absolutely have follow-ups. I will absolutely open invitation to my colleagues. We can work on some of these policies together, but we do have a lot of questions. So first one has to do with receivership. We've been informed that there's a 50-year inspection. However, when asked who would be inspecting, I was informed it would be a former building owner, condo owner, who now has his own company and who has been on the advisory board here for some time. Since we in the past had a bogus 40-year report, I should think an independent inspector would providing more confident assessment of our buildings and what actually should be done. As you know, we are in receivership. I gave the bogus report. Okay, I won't go into that. My question is, should there be an independent inspector rather than an in-house one, considering the bogus report? You want to tackle receivership.
Is the receiver making the decision on which engineer to hire? Is that what's
Yes.
happening? Yeah, oftentimes stuff like that, once you're in receivership by the court, the judge may have to approve the engineer that the receiver is actually hiring. Now, here you're saying a person is even on the board of directors and is getting hired by the board or the receiver to do the actual engineering. Yeah, I don't like that. Why? Why don't I like that? Because the person who's doing the report has a financial interest in finding that there's nothing wrong with the building, right? And that scares me. I don't like it. If I'm on a board of directors, yes, I think that's a terrible thing to have someone who has a financial interest make the decisions on, whether or not the building is safe, which is exactly why I think the statute has to be changed so that board members don't have this same opportunity to do the same. I mean, think about what's happening with your reserves. You get wealthy people on the board one year, right? They say, come on, let's fund the reserve account. They get thrown out of office. You have, quite frankly, poorer people, maybe people on fixed incomes. Suddenly, the life expectancy of everything in the building goes way up, right? And now you're not funding for reserves. The whole process has to be removed from board members who have financial interests in the reserve account funding. It needs to be done by an independent engineer or architect.
Representative, would you like to tackle this for a moment? I mean, I know you're the receivership go-to person as well. And also, would you like to verbalize your phone number? Because I really think it's that some of these, it's one specific building. I'm not going to get into it. But perhaps they should, reach out to you and have a conversation. And like I said last time, pick one or two people out of an entire large group. But if you'd like to talk about this issue real quick and then also verbalize your phone number.
Well, I'll put out my number. Half of South Florida's got it, so I may as well put it back out there. It's area code 305 and the number is 343-0776. I'll repeat it. Area code 305-343-0776. So real quick, I agree with what Eric is saying. I'm not a fan of receivers. Unfortunately, there is a need for receivership. When believe me, when a receiver got put in there, it's because it needed to be there. Unfortunately, I think, in my opinion, and again, a lot of people disagree with this, I would rather have a group of people come together, hire a property manager, hire an attorney, and go back and petition the courts to remove the receiver. But of course, you have to prove to the judge to remove a receiver. It's going to be quite a task, I should say. I in Dade County have been involved with the mayor and previous mayor to remove receiverships. Why? Because here's my personal opinion. They were charging way too much money. So the majority of the money was being spent on his expenses and on his contractors. And remember, he's got full control. He does everything. He's the board. He does everything he wants. Where again, time had gone by and these communities come together and they're ready. They really are ready to take back control. But I've seen receivers that have lasted 3, 4, and 5 years. There's a perfect example called Samadi Lakes in Hialeah. So there is some precedent here. But anyway, it does. I'm not in agreement. So I hope that if you have one, let's talk. Eric can talk to you about one side of it. I will talk to you about my preference is to, if you're ready, to help remove that receivership.
100% agree. A receivership is the worst thing that can happen to an association. Remember, the board members serve for free. I've been appointed as a receiver for, associations. And remember, if an attorney comes in and runs it, the attorney is charging by the hour, where the board members would be free. And the expenses can add up very quickly. So the last thing you want is a receivership. Now, the person that asked the question originally is saying, do we contact the judge? I believe you should, absolutely. In this situation, if you fear for your own safety and you don't have an independent person doing your 50-year inspection, I absolutely think the judge would be interested in that. No question about it.
Okay. Next question. Does the ombudsman provide services for co-ops or only condos? So no for co-ops and no for HOAs. But maybe I believe the ombudsman has logged off. He only came on for a little bit. He wasn't scheduled to come on, but he certainly wanted to hear some of the questions. Maybe that is something that we can work on, Representative. I think he would like to see a change so that it gets more teeth and more.
It's going to happen. It's going to happen. We're going to put him in the office of the Attorney General, God willing, and give him subpoena power and the power that he needs. Remember, this gentleman does not know it. He's an employee. It is the policymakers, Ana Maria Rodriguez, the senator, which will make these things happen so that this man can really do his job and not be hindered.
I see a comment about, does the ombudsman is a position that still exists, failed position to date? So I will say this. I don't agree with the last statement. So last year, I believe it was June or July 2020, Governor DeSantis actually appointed Spencer Hennings as an ombudsman who's been incredibly responsive, very engaged, goes from city to city. He jumped on today because he's really interested to know what your concerns are and what your questions are, but his hands are tied. And this is where where Representative Robaina comes, Eric Glazer, and Senator Rodriguez comes to go up to a state level and give him more teeth and more power. So I would, Janet, if I were you, I would join these meetings more often, and you should see for yourself. You might want to go back. You can look on my Facebook page, and 2 weeks ago we had a long meeting with the ombudsman. I think it might change your mind. With this gentleman is really very, very interested in helping you. But we need to, as electeds, we need to help him to be able to help you. Would you agree, Representative?
100%, 100%.
Okay, thank you.
Yeah, Spencer is really a great guy. And, he feels bad that when he gets telephone calls from HOAs and he hears horrible stories, he's like, I'd love to help you, but I just don't have jurisdiction. I can't do anything.
Right.
So, but his heart is definitely in the game. I can tell you that.
I agree. And listen, I'm not politically correct. I will back Representative Robaina about DBPR. It has been really a point of contention for me all of these years. I mean, I was elected in late 2016, and it really has been a complaint over and over and over again, dozens and dozens of complaints of inaction. And so I was thrilled when the ombudsman was appointed. But let's keep going. Does the ombudsman, does DBPR, Division of Condos, Mobile Homes, etc., apply to co-ops?
Yes, in certain situations, they do have the right to investigate complaints. That when their election disputes happen, they go to arbitrators in Tallahassee that are employed by the Division of Condominiums, Timeshares, Mobile Homes. So yes, in certain situations that they absolutely have control over cooperatives. It's something you can make complaints about.
And I will include all the contact information in a follow-up email. I'll also have it on my Facebook page. So if you look up Commissioner Anabelle Lima-Taub, you'll have contacts. I know some of you have asked for contact info. How does a small co-op get assistance enforcing 719 when the board does not follow it?
So the question is, who do you complain to, right? There's not much you can really do. The Ombudsman's office really can't help you. So oftentimes, you're forced to, do we want to get a bunch of people together and sue the board for breach of fiduciary duty, right? Or get an injunction requiring them to do something or not do something. And who has all the power? Who has all the money? The association, the board. The unit owners have to get it together and come up with their own money, and it's oftentimes difficult. So, the legislature tries to level the playing field. The only thing they can do is say, okay, whoever wins gets attorney's fees from the other side. But unit owners are at a tremendous disadvantage financially.
This is some HOA questions. So all you HOA fellow neighbors and friends, you're definitely not the stepchildren here. We have a master condo policy, yet we are considered a homeowners association. Some units have a homeowners policy insurance and others have a condo owners policy. Totally confused.
Oh, that's okay. All in the same community?
Mhm.
Yeah. So there's no way, certain questions you can't answer unless you have the governing documents in front of you. So there's no way I can answer that question without knowing whether or not the sub-association is a condo, if it's an HOA. But typically, if it's obviously if it's a condo, you would have what's called an HO6 policy.
Right.
That covers the contents of your home, and you better have that if you live in a condo. Covers you for a lot of things. And there should be obviously a master policy that covers things like the roof, the structure, if it's a condo. But in an HOA, you're responsible typically for your own policy, that if any damage happens to your own home. Condo, master policy, HOA, it's on you.
Okay, so if you'd like to send me an email answering questions, sorry guys, there's people walking by, my dogs see them. We're having a Zoom meeting tomorrow and the board is going to pass a document and parallel doc updated rules plus landscaping rules, yet the residents who live here don't know what the rules are and had no input. What can we do about transparency?
Julio, if you'd like to answer that, go right ahead. Oh, we might have lost him. So they're gonna vote on it tomorrow, and we need to know, was it properly put on the agenda? The only thing that the board needs to do in that regard is just put it on the agenda with 48 hours notice. That's the only requirement. Now, if they were making new, and this is because it's landscaping, it's not rules regarding unit use. If the board was making rules regarding unit use, they would have had to send the rules to the owners 14 days in advance. It would have had to be posted and the unit owners would have got it. But because these rules do not involve unit use, instead they're landscaping, if the only thing they did was put it on the agenda, that's fine.
So I do see if anyone from that particular HOA, if you would like to follow up with a question, just raise your hand, then I can have you chime in. Let me ask you, let me see what else they asked. Every year, we're supposed to be getting the end of the year statement of what was spent, etc. We will not receive the 2020 year end statement. Is that okay?
Oh, that's not okay. That's a very important question. It's a great question. So let me say this, generally speaking, the one good thing I'll say about the DBPR is they really don't want to hurt the condominium association if an innocent mistake is made. A few years ago, the policy was really adjusted to say, okay, we're going to give the board a chance to learn the right way of doing things. We're going to give them a warning letter. We're going to make them maybe take an educational seminar. Now, the one thing that really gets to them though, the one thing that you will be fined for is failing to have your year-end financial report prepared timely. That is like a signal and a half to them that the board is trying to hide something or that there's funny business going on. So if you're in a condo and you haven't prepared and finished your report, and typically how it works is within 90 days of the start of your fiscal year, and the fiscal year is typically January 1st to December 31st. So by the end of March, you're required to be under contract with the CPA to do your year-end report. And the type of report that you prepare depends upon the budget of your association. The bigger the budget, the more detailed report. And within 30 days after that, by the end of April, you have to let the unit owners know the report is done and that they have a right to get a copy of it by either walking into the office or having it mailed to them, all free of charge. If you blow that April deadline and a complaint is filed with the DVPR, rest assured that association will be hit with a $5,000 fine. I've seen it happen all the time. So there's one thing you need to be cognizant of and careful about. It's getting your report done timely.
But, you know, to that, if I don't know the board members, if the unscrupulous ones, it's important to note that the majority are really good. And
Unquestionably.
it's a thankless job.
Yeah.
You know, I live in an HOA. They do amazing work, and really they don't get paid a penny for it. But there are those that are unethical, so to speak. But it's not their money. So I don't know that they're really concerned about being fined, because collectively it's one collective pot of all the residents, and it's their association dues that pay for it. So what can we do? How can we empower state legislators to create laws to hold the board members themselves accountable?
If it can, I mean, and maybe you can get the legislature to pass a bill that would hold the members of the board individually liable if it's found that they deliberately did not prepare the report by the statutory deadline. That might be possible if you convince the legislature to do so. It is a weird situation when you think about it. You put in a complaint with the DBPR, you let them know that the condominium association did something wrong. You're right, they agree with you, and you, who made the complaint, wind up paying a portion of the fine. Think about that. Sounds crazy. You've just penalized yourself.
Correct. Give me 1 second. I lost this. Mr. Robaina, former state rep, lost signal, but he'll be back on next week. So we have so many questions and they keep coming in. So we'll follow up with him next week as well. I did have, can you ask a question? How do people interpret their governing documents to know if they have Kaufman language or not? And where would that language be found?
Typically, it's found in the definition section of your governing documents, right up front, right on page 1. That's typically where it's found. And it would say the act, right? Or the condominium act. How is it determined? And it'll say the condominium act is defined herein as the laws that exist on the date this is recorded. And hopefully you have, and as amended from time to time. Hopefully your documents say that. It's typically found in the beginning.
Going back to the, in the beginning, you said it's typically.
Yeah, typically the first or second page, typically of your declaration.
Okay, going back to the HOA quickly. The agenda is for landscaping and the parallels dock. The dock is limited common area for the exclusive use of the unit that abuts the dock and water.
Okay, so then I guess the person is asking, is it possible then a 14-day notice would be required? Yeah, that's certainly a good argument if you could argue that technically it's a limited common element and part of the unit, but the dock obviously is not a unit. So I don't know if you can really make that point. Dock is something totally separate from a unit, and the statute says that longer notice is required only if they're making a rule regarding the unit. So tough call. I think it would be difficult to convince a judge in that regard.
Okay, I'm going to take one more question regarding receivership. I've implored those of you that are in the building under receivership to, reach out to Representative Robaina. You can reach out to Mr. Glazer as well. So I'll take one more question, but you now have 2 resources that you can reach out to. Mr. Glazer, being under receivership, I requested numerous times for expense reports. Never got anything. The receiver response has been that she sends a monthly report to the advisory board members that she chose, but the advisory board members don't share the info. How can we get the reports? Also, I requested the reports that are expected to be sent to the judge reporting the association and the evolution. no info shared. Do we have the right to this information and what can we do?
Yeah, just because an association is in receivership does not mean that the association doesn't have to comply with the access to records requirements of 718. So it's absolutely, the unit owners are entitled to the official records of the association. And I would certainly argue more than ever when that condo is in receivership, right? So if the receiver is ignoring them, if the board members are ignoring them, yes, you can intervene in that lawsuit, right? If you want to, you can intervene in the lawsuit and let the judge know, hey, there's a receiver here, there's a board here, and neither one are keeping the unit owners advised as to what's going on, and they're failing to comply with records requests that we're entitled to under 718. So, but you got to get involved in that lawsuit.
Okay. I think what I'll do is I'll have like mini sessions, not like an hour and a half, but maybe 45 minutes or an hour specific to receivership. One that will be specific just to HOAs.
Sure.
I know there are a lot of condo owners as well on here, so we want to make sure we cover everyone's questions. We purchased our condominium a little over 3 years ago. There have been multiple water issues involving pipes that we know of. I'm sure there are some that we don't know about. One, if we ask the management or the condo board, do they have to disclose all water issues to us? How about anything that might have affected our unit? We know of one that affected our unit that occurred several floors above.
Okay, so under the statute, the board is required to maintain the official records of the association for 7 years. So what does that mean? You can make a request in writing, and you have to make the request in writing, not by email. Okay, the email request means nothing. So you have to make the request in writing to the board, to the manager, saying, I'd like copies of the following records. You know, A, any inspection reports by any plumbing company or engineer in the last 7 years. B, copies of any and all estimates. C, copies of any paid bills, you know, on and on and on. You can get access to all of those records. Every single one of them has to be maintained for 7 years. They're required to give it to you.
May I jump in here as well?
Yeah.
Also, you know, we have public records in our city.
Sure.
So what you could do, and obviously you'll be charged for it, but, you know, you could actually, but be specific on what records you would want. And if they're on file in the city, obviously we don't have, we have different retention policies on our records, but you may be able to find information with the city as well.
Sure. Yeah, what permits were pulled. Absolutely.
Right,
If any
exactly.
permits were pulled,
And you
sure.
can go online. I said it last time, and I might as well jump in there just really quickly. Commissioner Taub, what she's done to get that information in regards to condos specifically is on there. And obviously it's a work in progress, because as this evolves, there's more information that I think is very timely to everyone have their fingers on. But if you go online, in our building department and building permits, you can find what was filed. You can find the permits. So I really encourage everybody. Our staff is working hard, and we've gotten a couple black eyes lately, which have been confirmed that they're no fault of ours. So obviously we encourage everybody, and we want transparency and want access. So if it's a public record, you have access to it. So again, you can even do that online, file a public records request. They will tell you beforehand how much it will cost, or, you know, and that depends on your language. Usually I suggest as narrow as possible. And just wanted to interject that. So excuse me, Mr. Glazer.
No, not at all.
And I just want to, just one correction, the ordinance covers condominiums, HOAs, and co-ops, because that was a question whether or not our ordinance also covered co-ops. It covers all three. I don't know what Janet means by estimates for 7 years.
Yeah, I think she's like bids. I don't believe bids have to be maintained for 7 years. I'm thinking it's 1 year, but honestly, I don't know the answer to that question.
I'd like to know the answer to that.
I could research it and get you tomorrow,
Do you,
but I
do you
don't
mind?
think.
No,
that-
I need to know because, and I might as well say it publicly. I'm actually drafting a letter based on a lot of this input and some other input from people on the committee. And frankly, I believe that, and I heard and learned last meeting that language is not strict with as far as bids, closed bids, sealed bids, how they're received, what is happening with them. And quite frankly, I believe once bids are received and they're voted on and there is assessment, they should not be overruled by a simple vote of the board. And I'd love
going-
your offline, if you want to comment on that, I'd welcome you to contact me, Mr. Glazer.
Yeah,
But
no,
I
I'm
think
looking at the
that is
statute.
part- that
I'm
is
looking at the
part of
statute
the-
now.
Okay,
And
thanks.
it's 7 years. The way I'm interpreting the statute,
Okay,
is
good.
even bids have to be maintained for 7 years.
Good. Okay, so
Okay.
thank you.
Sure.
Because I think that's vital information because we have bid shopping, we have people being voted out that work hard on boards to get to this
Yes.
point and have to make these decisions. And then, okay, we don't like them, we're going to vote them out.
Yeah.
That has to stop.
Of course.
That in my mind has to stop.
Is that for HOAs? Is the 7 years for HOAs as well?
Yes, correct.
Good to know.
Same thing for records, yes.
So Commissioner, may I jump in?
Thank you. Hi, Commissioner.
Hi,
Go ahead.
Mayor. Hi, Mr. Glazer. How are you?
Hi, how are you?
Good. Along those lines, I have some complaints often, which it's hard to believe that it's allowed or legal, but it happens more often. And I'm sure you know this, that people that are on these boards don't live in these buildings. This is not their homestead. This is their vacation home. And it may just be one vote shy of them not getting that seat and they don't live here. And the people that are there year round don't get a say when these people aren't there. I know votes have consequences. I know that it's a democracy, but that, being said, does that sound right to you that people don't live in a home could have those life or death decisions?
It boils down to, under Florida law, as long as you are a unit owner, you have the right to be on the board. And I got news for you. It goes further than that. Let's say your documents have language in it that say if you miss 3 board meetings in a row, you're off the board, right? Things like that. All those provisions are found to be illegal by arbitrators in the courts. Yeah, the only way you can get off a board is by really the recall process, or if you're actually caught stealing. That's it. So you could make the argument both ways. I'm still an owner. I pay my assessments like everybody else every month, right? I'm entitled to run for the board. If people don't like me, don't trust me, don't vote for me.
So the
But I
question
certainly have
then,
the right to run.
I guess it becomes unethical just because it's legal doesn't make it right. I mean, we
Right.
know the difference between what's legal.
Some associations, believe it or not, you don't even have to be an owner to be on the board of directors.
Somebody just asked, Trisha just said, can non-owners serve on boards?
It depends what your bylaws say. It's very rare, but it happens.
Right, and that really what everything comes down to is the bylaws, because somebody
Correct.
asked me today and I said, look, even if your bylaws didn't say that, the city's not getting involved in what
course,
your
right.
bylaws say, right?
Private matter. of
Along
course.
those lines, we've had, and I will call out the condo, the Olympus has been a building in question. And I know the mayor has an experience that she wants to tell from her committee, but I just, it got back to me today. A letter went out to the whole commission that the association was reaching out to a PR firm to wage war against the city for protecting or taking legal action to protect their residents at the request of some very concerned owners who do live in a building of which that board
Right.
president does not live in that
Instead,
building.
yeah.
Huh?
That actually, they I guess they learned that from the board at Champlain Towers. Yeah,
Well,
when
they
that board, and I don't know why, because quite frankly, they did not need it. They hired a PR firm, about a week or so after the collapse. So I guess this board, I've never seen it before.
Well,
and now I've seen it
irony,
twice.
I guess the irony of the story is that they reached out to the city's PR firm,
Right,
not realizing that they work
Karma.
for us.
It's called karma.
right.
Yeah.
Karma.
Karma's a
That's-
boomerang.
issues shouldn't be decided by who has the better PR firm. It should be
It doesn't
decided.
matter. I'm only saying, I'm going to say this publicly.
be
because
legal.
The board, the city commission is here. The majority of our city commission is here. And I'm going to let my personal feelings be known about this situation. The fact of the matter is the city took an action that they felt was legal and needed. And for any association in light of what has happened in Surfside, to not only want to lash out about that, but to make it about dollars and cents, that how dare we do that because it cost more than it should have if we did. This is not that kind of climate. We're dealing with some major structural issues here.
And it's great to see municipalities, in all candor, quite frankly, having their building officials finally go out and take a look at some of these buildings. Because as you know, you can build a building, it gets its CO, and then no building official sees it until the 40 years. It's insanity.
Well, not only that, they had the engineering reports, they had the assessments, they had the money, they had everything. What they didn't have was a board that needed to take action. That's what they didn't have. So that, to me, for me, and I think for the mayor, I can speak for the mayor and, hopefully for Commissioner Taub, this majority stands by the Olympus, stands by the city. We're not going to be bullied by a board or a member. So I just wanted to kind of put that out for the Olympus people who may or may not be listening for or against the situation. The city stands by what it did, and this commission stands by the city. So that being said, Mayor, if you want to follow.
Yeah, no,
Even though you had 2 engineering reports said that the Olympus was safe.
I'm sorry, who's speaking?
I'm sorry. If you need to put your hand up, I cannot have anyone jump in. So if you'd like to speak, put your hand up, or please type in a message, comment. This is really about condo and HOAs, and if the elected officials want to speak about a matter, they're more than welcome to. If you want to chime in, either put your hand up, please, or write in the comments section, but please don't jump in.
Let me just, and thank you, because we've kind of had like 2 cauldrons going on. One was hemispheres and one is Olympus. Olympus language was, there was imminent catastrophic failure. I'm going to repeat it. Imminent catastrophic failure. Ironically, LTM testified at the board meeting in regards to not just this condo, which I found out because they weren't mentioning names, about firing condominium boards for not doing the right thing. Now they're ethical, they're doing what they have to do, and they went, we're not getting involved with this. So I will reassure, and I've been very vocal, obviously, that I believe, and I alluded it to, you need to get these sealed bids. You need to get 3. They need to be done. They needed to be voted on. They need an assessment passed, and it can't keep churning. And one of my concern is there's loose language about, I'd like to think it's objective language coming from engineers and building officials. They have the objective strength to say, no, this isn't right. But some of it's subjective about extensions and critical components of a building. And, I can see, especially what's going on, you might not be able to secure the contractor right away, but there has to be a concerted effort. And the question I'm posing to the board on Monday is, how many extensions should you be afforded? That's the other question. And based on what? So, there's a lot of work to be done, but obviously, and people were, I had board members from other areas that have represented maybe 15 condos saying this shouldn't be about the boards and it shouldn't be about CAM. It's obviously about everybody. We've all dropped the ball to a certain extent. And I alluded to that to attorneys, that they have an ethical duty to uphold the law too. They're sitting there. As a city, we have the power, and we must go after these condos that aren't doing it. But when you see imminent collapse, and you know, I was shocked. I was shocked on Thursday. And then I found out that that was one of the groups that was kind of fired, but they're back in because now the board president had no choice. He had a choice 2 years ago to do work. So there, yeah, it'll have to
So
change.
Mayor, if we can
Thank
leave the Olympus conversation.
I know,
or
I'm
like the
sorry. I
end,
don't want to
towards
go
the
that
end.
into it.
Let's leave it towards the end. All of us are
Right.
here. We can talk about it, but I want to make sure we get through the questions. I'm not in a rush, Commissioner, Mayor, if you're not in a rush,
Right.
but let's get through the condo questions.
Right.
And then we can pick this back up. Mr. Guthrie, I'm not ignoring you, but let's wait towards the end of the meeting. Let me get through some more of these questions. Who's responsible, the owner or the condo, of any damage that has occurred to our unit by someone else? They dried out our unit with fans and said it was all fixed. We're now suspecting that we may have mold. Who's responsible for checking and fixing this? If
Okay,
true.
so if the leak, let's say the unit above you has a leak and it damages the walls of your unit, the walls are typically common elements. So even though the board, the association did nothing wrong, it's the association still that has to put back those walls, right? They're the ones that has to repair it. If the association wants, to the extent it's not covered by insurance, they can go after the owner who caused the damage. So if there's mold in your walls, and this happens routinely, yes, if those walls are common element walls, and if they are loaded with mold, it's up to the association to remove them in a proper way, in accordance with mold protocol, and replace them. That's the association's problem.
Got it. I failed to mention this in the beginning of the meeting, but this is a publicly noticed meeting. What that means is that our elected officials in Hallandale Beach, we can all be on this Zoom virtual meeting and discuss past, present, or future policies that we'll vote on. I know I seem very punctilious at times, but I just want to make sure that everyone knows we are not in violation of the Government and Sunshine Law. And also, I know that few of you asked for a copy of the Condo and HOA Transparency Act. Tomorrow I have an amendment. It's on second reading, so please wait for it to pass tomorrow. And then I will be more than happy to forward it once the mayor signs off on it. So I proposed an amendment related to engineering reports and recertification reports and so forth. So it's on second reading tomorrow. I expect it to pass. Ms. Vanderbeck, I see your hand up. Maybe you want to type in your question. I do have a list of people that send in their questions. So if you'd like to type in your question, hopefully I can get to it. Our numerous board members were recalled based on numerous reasons, even though they were told work needed to be done. Disrepair was causing damages to the building. The board was not helping owners or unit owners or following directions and instructions. How do you prevent damage to specific unit over years, rather abusive owners, other than listening, replacing and repairing? This is a very, long question. Let me see if I can narrow this down. The board told the replacement needed to be done to prevent concrete cracking. Instead, the board wasted money. Okay, whoever sent this in, I need you to condense this question and resend it to me, please. Can a member of association to serve in the board while having a code enforcement and a civil violation for performing renovation of their apartment without getting required city permits?
Yes, they can still be on the board. They can still run for the board. Absolutely. There's very few things that prevent somebody from running for the board. One is if you're delinquent. The other is if you have a felony conviction and your civil rights haven't been restored for at least 7 years. Other than that, you can run.
How do you stop members of the board to use association resources such as funds and efforts of the maintenance personnel to renovate their apartments? Can the DBPR help in this issue?
I don't think the DBPR helps. Quite frankly, that could be a criminal case. You know, if a member of a board is using, the handyman to do stuff in their house that the association is paid for, that's theft. right? And unfortunately, you know, a lot of police departments, and not so with Hallandale, but a lot of police departments consider all of this type of stuff civil matters and they don't want to get involved. But, you know, if you can prove it up and you got video of pictures of the maintenance guy coming in and out of that unit 10 times during the week, yeah, I think that a police department may in fact be interested in it. It's a crime. But you're muted, I think. Yep.
I'm
you are.
muted, of course. Would you provide telephone and emails for all different complaints regarding zoning, construction, electrical, and board issues? Please to email list you already, okay, that was to me, I guess. Okay, yes, absolutely. Ms. Vander, went up. Ms. Vanderbeck, you said you asked earlier and the question was missed. Typically what I do is I ask you to please email your questions ahead of time. And so the questions that I'm reading out are those that email the questions. But if you'd like to send me a direct message or ask it publicly on the chat, you're more than welcome to, and I will. I'll ask your question. Can the president of the board use assessment funds for renovation of individual apartments, including apartment of the members of the board during the 18 months without approval of the entire board?
No, absolutely not. No, you shouldn't be renovating units. I don't know, you don't know what that means. But any major repairs done in the community obviously needs to be voted upon by the board at a properly noticed meeting. It, you know, kind of troubles me that it wasn't and it's being done by members of the board. You know, if that's correct, that's potentially a serious issue.
So would you verbalize? The reason I asked you to verbalize is because of the closed caption as well. Would you verbalize your phone number? Maybe some of these residents need to give you a call.
My phone number?
Yes.
Sure. 954-983-1112.
Would you repeat that one more time, please?
Sure, 954-983-1112.
Okay. Would the unit owners be grandfathered in against oppressive new rules passed in a monthly board meeting? No 14-day notice or quorum of owners at meeting. The rule in question is that the owners and tenants have credit score over 660 and income over 45,000. In the past, the rule was applied to the applicant on the lease with exception made if at least one of the two parties had the score. Now suddenly a new board enforces as every occupant, even those children over 18 must also be screened.
Okay, those types of rules cannot be done by rule. Okay, so boards generally have the authority to make rules and regulations regarding the health, welfare, safety of the community and of the common elements. They generally have that power. However, that power ends when what they want to do conflicts with the declaration of condominium. So you have to look at what the declaration says about whether or not they have the right to even screen, approve, or reject people that want to move in, right? And those specific provisions that they want, like credit score, for example, and no prior felonies and all that stuff, that's got to be done by an amendment to the declaration, not by the board passing a rule. The board can't take the easy way out and just pass a rule at a meeting if it's a subject that's already discussed in the declaration of condominium. And that declaration of condominium for sure and for certain has provisions in there already that talk about what the procedures are if someone wants to sell or rent. So if they want to add new procedures, you got to amend the declaration, not make a rule.
Got it. Okay. Let me go. Somebody asked me to go to the top. So let me go to the top for a moment. In order to send emails to unit owners as the preferred means of communication, does a vote needs to be passed by the unit owners?
You know, if a unit owner wants to receive notice of meetings by email, they need to sign a form, right? Requesting that the board notify them by email. Now, once they sign that form and once they give it to the association, their email address now becomes basically public record in the condo. If anybody wants the email addresses for anybody who submitted a request for notification by email, the unit owner gets it. Hope that makes sense.
Okay. I requested financial for 6/21 for management company. They responded that it can take 60 to 90 days. Okay, I think what she means is June 21st. This management company took over July 1st. Is that a normal time frame?
No, the statute requires 10 days. Access to records have to be provided within 10 days, period. So no, waiting, I don't know how long, I don't remember how long it was is the question, but bottom line is the access to the records have to be made available within 10 days.
Mayor, can you take over to Marcelo's question, please, while I shut my dog up, please?
I didn't see more. Oh, how can condo owners not report wrongdoings from board members and or contractors? Oh, boy. Well, contractors are one thing. Contractors, you'd have to report to the building officials.
Yeah.
As far as the board members, you it depends on, I guess, what the complaint would be. You could report it again to the Ombudsman. If you believe there's fraud or theft, we do have a white collar crime unit. It's actually one person, but we will, if we believe there's condo theft or that type of wrongdoing, we will have it researched. But again, going back to Mr. Glazer, it can't be like a supposition. You have to say this happened, that happened, this is what the record was. So I would suggest you reach out to Scott Hennings, but if you have a contractor that's doing illegal things, that's Board of Rules of Appeals and our building officials should be aware too. And I would suggest you reach out or copy one of us if you have any wrongdoings, and code enforcement as well. So
My
we do have
husband got the
venues
dog,
for that.
so we're
Thanks.
good.
And I know Commissioner Lasser, I put some links in. I do not have Scott Hennings' link. If you want to put it in, or if you didn't already.
Spencer Hennings, yeah, I'll put that in. Let me
Okay.
just get to the questions because I know
Yeah.
Mr. Glazer is going to have to get off. If board member signs from saying they read documents and do something wrong, then can they be sued along with the management company? I think that goes back to what we discussed earlier about holding that on a state level, holding board members personally liable.
Generally, yeah, anybody can get sued, board members can get sued, but it's very, very difficult to get individual liability against the board member. You basically have to show that they committed a violation of the criminal law, right? They stole money, or they deliberately sought to harm somebody. In other words, they sued a person because they didn't like their race, religion, color, etc. They did something deliberately. You know, very, very difficult. Acted in disregard of their health, welfare, and safety. You know, like deliberate acts. That's the only way you're going to get individual liability against the director.
If I may, and I just heard a story about this, and somebody won. And it goes back to intimidation, and it goes back to even what's happening currently with Olympus. You can't like defame somebody in your condo and accuse them or intimidate them, correct?
Absolutely.
And that is illegal. And
100%.
I spoke to somebody that actually did and won.
One.
So yeah. So any whistleblower, I hate to use that term, there has to be a better, any person that's like consciously social and wants to do the right thing, and then they're being attacked or minimized and disparaged in their unit, you cannot do that.
Or even sued,
Right.
sued.
Yep. Mm-hmm. And this person won. I mean, I said, well, now all the neighbors are upset because it cost them money, but he won. He went to court, and that's what
The
happened.
Florida Condo Act actually recognizes that, Mayor.
Yeah, no, I didn't know.
There's something called an illegal slap suit, strategic lawsuit against public participation. So if you voice your opinion at public meetings, for example, and the board starts coming after you for things, you move to dismiss the case because judge, they filed what's called a slap suit against me. They want me to shut up.
Thank you. Thank you. I didn't have the legalese, but it's interesting.
Well, and it goes to a point where every single meeting that I have with residents, I ask them, please do not, and when I send out emails, don't mention your board members' names, don't mention the association, the management company. Don't mention it.
Right.
Because another form of intimidation and intimidating people, residents, is by suing them for defamation. So let me see.
Works both ways.
Little known fact, if your Florida condo is a second home, you can put a rider on the condo for liability. Okay. All right, I think I will make a very, a one-time exception, I can't see where she, Vanderbeck. Miss Vanderbeck, are you still on here? No, did she step off? Okay. I'll ask you one more question. 21-year owner, I'm not allowed to park unless I give them my driver's license. Do they have to put writing into an amendment to need a driver's license to park in my parking space?
Yeah, I would think so. If the documents probably talk about how parking works, right? You know, what you need, you automatically assigned a parking space. If it talks about the topic, the only way to change it is to do an amendment to that provision. Again, not make a rule. If the topic is already spoken about in the declaration, you can't circumvent the declaration. You can't go around the declaration by just simply making a board rule. You got to do it by an amendment to the deck. So I would say, yeah, you shouldn't be asking for the driver's license.
So I'm going to ask the last two questions, and then we can go back to discussing anything that you'd like.
Commissioner, can I just say there's a recent case, by the way, that basically talks about that, where association asked for income tax returns for people that want to move in. And they did a background check. They did everything. People were great, but they still weren't satisfied. They wanted income tax returns. And the judge ruled, no, where does it say in your documents that you can ask for income tax returns? It doesn't say it. So the same thing, where does it say in your documents that you can ask for driver's licenses? So same thing, I think it would be struck down.
Thank you. So last two questions. The board of director vets potential renters and new owners. It seems that the percent of potentials are not people of color, albeit of a Slavic heritage. Should we put in a formal complaint to the ACLU?
That's up to you. I can't answer that, you know? That's a personal decision.
Okay. And the last question is, in a 5-board member condo association, can the 4 members remove the 5th board member?
No, they can remove, this happens all the time. There's oftentimes confusion between the board and the officers. Okay, typically they're the 5 people get elected, and you make one of the 5 a president, a vice president, a secretary, a treasurer, maybe another vice president, and those are the officer positions. The board can remove that 5th person as an officer. They can take away their title, but they cannot remove them as a board member. They still get to vote at all board meetings.
Okay.
Only way to remove somebody is the ways we've spoken about before, like recalling them, or if they become delinquent, etc.
And I'm sorry, I missed this one. I promised the last one. The association took a person to court for supposed mold due to a small leak that the person had in the AC closet. The association was paid. What obligation does the association have to get the supposed mold repaired?
If it's probably in a common element area, right? And if it's in a common element,
in the respective AC unit,
right.
Closet.
But so you have to see if that's a limited common element, and if it is a limited common element, it's still the association's responsibility to fix it. So if they know of mold, and again, I'd have to read the documents to make sure that the closet is not part of the unit, right? And it probably isn't. If it's a limited common element, it falls on the responsibility of the association. For example, what's a typical limited common element? Everybody's balcony, right, is typically a limited common element. Even though you have the right to use it, it's the association that has the responsibility to repair it.
Attorney Glazer, I want to thank you so much for your time. If you would one more time share your contact information, and then I wonder if you could look at your schedule and see if you'd be available on the 31st, because there's so many more questions it's flooding in, and it's just the time is.
No, I'm honored. Again, thank you, Commissioner Taub and Commissioner Lazaro, Mayor Cooper. Thank you so much. It's been an honor to be with everybody, and of course, Mr. Robaina as well. It's my pleasure. And what's today's? That's about 2-3 weeks away, right?
It's 2 weeks from tonight.
All right, we should have no problem. Okay, it'd be my honor.
Oh, that would be wonderful. Somebody's thanking you for your time today.
Thank you very much. Pleasure to be with everybody. Okay?
Okay, so I said next week would be the last one, but what we'll do, and then we'll have it monthly, but what we'll do is we'll have one more next week, and then the following one, we'll have one final session with Attorney Glazer, and then we'll go to having these meetings once a month. So Attorney Glazer, you're more than welcome to stay on. I think there were some questions regarding the Olympus, and so I wanted to make sure that those that came here for the condo HOA co-ops, that they got their questions answered, but now we can have a few minute conversation about the Olympus. Commissioner Lazaro, are you still on?
All right, guys, thank you so much. I appreciate the
Thank you.
opportunity.
Thank
Yeah,
you
you're
so
welcome.
much. Really,
Thank
truly,
you.
thank you very
Thank you
much.
so much. Okay, good night, everyone.
Thank you. Commissioner Lazaro, are you on? She log off? Okay.
I can't tell.
Yeah, I don't see her on here. She might have logged off. In any event, yeah, I mean, I'll just say that, I received an email last week and from city staff, and when, it's the opinion of a professional that it's a catastrophe if, and that the building is imminent, the structure, was it the AC? Was in,
Cooling towers.
Cooling towers. Thank you, Mayor. Presented imminent danger, and could be catastrophic. I definitely at that point stand with staff's decision and the city manager's decision. You'd have to wonder why you would, why an association would go to a PR firm and spend $100,000. Why not take that $100,000 and commence the repairs that are necessary? I also feel that in my experience of doing this in 4 years, is I saw the email that was sent out to the Olympus residents saying, well, now you cost us $100,000 and it's going to be $92 per unit. To me, it's an intimidation tactic, but that is between board members and the Olympus owners. But I did send an email. It's public record to the city manager's office saying that I am in full support of city staff. And I'm not really, I'm baffled as to why you would why the association would hire a PR firm and not concentrate on the repairs that need to be done. But this is people's lives at play here, and I anyways, Mayor, if you'd like to.
Yeah, no, I think I elaborated on it, and obviously we're not going to be intimidated. And actually, our building official has to uphold these laws by code, by state statute, and by his license. So when he finds those conditions, he reports it out. And obviously there was an executive decision, which I fully agree with. And again, I find it just mind-boggling that I continue to hear that there's money in bank accounts that are not being expended to address imminent building failures. I mean, the whole, and people are, well, it's the cooling tower. The whole point is a huge cooling tower, if it collapses, puts pressure on a roof. And I'm not talking about the membrane roof, I'm talking about the cement structure of the roof. So if that collapsed, not only will water deteriorate, but the weight of that would have collapsed it. Would it collapse the whole building? From my understanding, what I've disclosed, no, but it would have been an imminent failure of possible floors, not just a matter of water or leaking. So I agree with Commissioner Taub, Commissioner Lazaro. I thank her. We do this. We have a passion for it, and that's what we want to do. But we're here to protect people. But I do have to say, and I know Commissioner Taub said it, and I've said it publicly, there are boards that function great. They're doing the right thing, and those that aren't, that are trying, kudos to them. There's resources for help. There's and I'm debating, one issue that I'm debating. There's a 20% inspection rate of condos, and then they actually morph in a projected bid. And to me, I've been debating, I'm going to continue to debate it, who picks that number? 20%? Is it 50%? So residents need to understand these repairs, these security measures, these infrastructure, like I call them, measures that have to be done are extremely expensive. So please don't complain if you're getting an assessment. Complain if you don't think they're doing what they're supposed to be doing. Complain if they did a partial, like if you just inspect your balconies, that's not a 40-year inspection. You have to inspect the whole envelope. So, there's no cutting corners here. But if you do have a board that's doing the right thing, if you do have a board that says, guess what? We have a $3 million project. I'm sensitive to your needs. I'm sensitive you're on a fixed income. We have to pass this. Just make sure and verify it, but don't start voting them out to try to kick the can down the road, because I'm not going to have any sympathy for you. I had somebody come and they're upset. They're doing some balcony renovations. They're like, well, they want to do glass instead of this. They're not replacing it the exact same way. Obviously, it wasn't to code. So all these new balconies have to be to code. Obvious glass, railings, that's a personal choice. And obviously, you vote in your board and they're going to do. But most of these inspections that I've seen require this work to be done. So it's a balancing act, and we need, and thank you, Commissioner Taub, for doing this, educating people. If your board isn't like Olympus doing those repairs, doing those things that they have to do, we're going to enforce the law. And start September, you're going to see on that list a lot of pendings. We're going to see what has to be done. They will be public records. All those inspection reports will be public. So you'll know, we'll know, and work has to be done. But we can't defer it for 2 years because somebody decides they don't want to do it or wants to sit on money. That can't happen any longer.
So Mr. Guthrie is asking, did the city even read Epic's, the engineer of record, report there was no chance of imminent failure?
I have no idea what you're talking about, sir, but I know our building official actually went out, looked at your cooling tower and inspected it. He is a licensed building official for the state of Florida. That's the other pet peeve I have. A lot of people might not like me, but I'm going to be candid. Just because you're an engineer in Ohio doesn't mean you know every building code in South Florida. Just because you were a finance director somewhere doesn't mean that you know everything and everything there needs to know about these issues. Our building official is in charge of life safety. He does not take his license lightly. He is licensed by the state of Florida. He is licensed and certificated. So if you're going to question a building official in our state, I would hope that you were a certified building official in the state of Florida to question his behavior. Thank you.
Thank you. So to that, I'll just make a quick announcement. We will be back next week, 6:30 Tuesday, and then the following week, and then we're going to do this once a month. I did reach out to state of Florida education supervisor, Ms. Rodriguez. I am working with her. Hopefully she'll be on next week. I am working with her on logistics to offer classes for condo unit owners, anyone that wants to serve on the board. There are multiple classes that you should take in order to serve on your board, or if you're thinking about running, it has to do with finances, and I think there's about 6 or 7. There's a series of classes that you should take. So I'm working with Ms. Rodriguez to offer it here in Hallandale Beach. So I will hopefully have that finalized by the end of the week, but she will be on next week. So will Mr. Robaina, and I might get one more person for next week. And then the following week, we can do part 2 with Attorney Glazer, who's not able to attend next week. So we have 2 more of these scheduled. Mr. Guthrie, you are more than welcome to attend our meeting tomorrow. And you know, I think my colleagues and I are, at least, I'll speak for myself, but I like to be completely transparent and not hide anything from any residents. So please feel free to come to the meeting tomorrow and ask any questions you have, so that everyone could hear it, and people that watch our meetings or attend our meetings. But I support you, Mayor, with your comments. So,
Thank you, Commissioner.
of course, I don't think Commissioner Lazaro is on anymore. So we will see you next Tuesday. I'm going to type in my email address now. If you'd like to receive notices about these meetings and future ones, I'm going to do little meetings, like sub meetings dealing with just Kaufman language and the like. So if you'd like to be added to my email list, I'm typing it in the chat. Wait, I'm sorry, give me 1 second. Everyone. @cohb.org. Okay, my email address is ataub, A-T-A-U-B as in boy, @cohb.org. My phone number is 305-924-7471. I'd like to take this opportunity to thank Mayor Cooper, because I will tell you that this ordinance did not come easy. It took me years to work on it. It was with our attorney Glazer and Representative Robaina, would not have happened. I have invited all of my colleagues to join these meetings, and the only ones that show up are Commissioner Lazaro and Mayor Cooper has always been very supportive of condo initiatives or condo fraud initiatives way before I was even elected. But my hands have been tied for the last 4 years because one of my colleagues put forth some kind of a protocol manual where I basically can't use the city attorney for policies that I want to work on, and I have to ask the commission for permission, which no other city does this. So, I need you to show up and continue being supportive. So if you would like to please, if you'd like to join future meetings, please send me an email or call me. Again, my number is 305-924-7471. My email is ataub@cohb.org. Mayor, would you like to please verbalize your contact information for the closed caption?
Yes, okay. It's jcooper@cohb.org. And my phone number is 954-632-5700. Thank you very, very much. Thank you, Commissioner.
Thank you, Mayor. It's been, my pleasure. I wish we didn't have to have these kind of meetings, but you have me here for the next three plus years. I'm committed. Mayor Cooper.
Me too.
See you all next Tuesday. I will send out an invite in the next couple of days, and we'll see you next week and have a lovely. Yes, Mayor.
As a side note, just so everybody, because I just wrote about this and a lot of people, thank you, whoever reached out about the water leak on Hallandale Beach Boulevard. It is getting repaired. It was scheduled to be repaired. We had a back order on an old 14-inch water pipe. So be prepared. We're going to have some dust and some inconvenience with traffic, but it will get fixed. So please call us, text us, visit the HB app and report. We depend on you, your bosses, to be our eyes and ears. And I thank you for that. We welcome your input.
Yes.
Thank you.
Thank you. Thank you, everyone. Have a lovely evening, and we'll see you next Tuesday.
Great. Thank you.
Bye, everyone. Bye-bye.
Bye-bye.